Good afternoon, everyone, and welcome to today's webinar. Today we have a special guest, and I'm going to introduce her shortly. But let me introduce the topic first. We'll be discussing why estate planning is essential for sole proprietors and partners, and how proper planning can protect your business, your legacy, and your loved ones, which is essential for all businesses, and we will have more discussions about this. So let me introduce myself. My name is 𝘁𝗵𝗃, and I have experience in family law, civil litigation, criminal court, and in various roles over the years, which I have attained through my legal experiences in working with court service division. I have also worked closely with justices, lawyers, and legal staff, and now I have opened up my own legal practice and have been working as a business lawyer, as well as civil litigation and criminal law. So now I'm going to introduce this very special guest, Ms. Vettyvel, sorry, my apologies. And she's going to tell her whole story, and she's got a prestigious law firm in Scarborough, which she's going to let you know what she practices and how she's actually doing her legal practice. So let me hand it over to her.
Hi, everyone. My name is Rishani Vettyvel. I'm the founder and principal lawyer at Vettyvel Law. So my predominant area of practice, I do a ton of real estate work. So whether you're buying property, selling, refinancing, getting mortgages, all things like, I do those. And I'm also quite well versed in wills and some corporate stuff as well. So today we'll be talking about a lot of wills and how they apply to businesses. So thank you, 𝘁𝗵𝗃, for having me on today in order to support this webinar.
Well, thank you for coming on to my webinar, actually. It's really, really great to have someone who's very knowledgeable and can explain what wills and estates are and how businesses will benefit from it. So let's start our webinar now. Why estate planning matters for business owners. Business assets form a major part of personal estates. So you have to remember, these business assets are not secure if your business doesn't have proper protection. And as we've spoken on several occasions, there's various ways to protect yourself, including insurances, as well as wills and estate, which is what we're going to discuss today. So lack of planning can cause operational chaos or loss of value. So think about these aspects, because in the long run, if you don't have a proper plan, if someone passes away and the business, what is going to happen to it? Is the profits going to just be dissolved and provided to the shareholders? Or if it's a sole proprietor, the business is going to go under. These are things that we all should be considering whenever we approach a business structure. So let's go to the next topic. What is the importance of a will for a business owner? These are things to consider when you're actually creating a business, because you have a business that might be like, as I indicated, if someone passes away, we don't know what will happen to the business structure, who will inherit the business's interest, who's going to be the shareholder receiving those shares of the business when a shareholder passes away. Or if a person who's ill, let's just say you're a sole proprietor. Now, if you become ill, how is the business going to continue? And, sometimes we get ill for a short-term period where we need a power of attorney, which we will discuss further and have more information about. So these are things that we can discuss to protect the business continuity. And these preserve the business for long-term and better growth. We have to make sure that these are all aspects that we consider in the long run. And this is where we will be talking further about unique challenges for sole proprietors. So let's go to the sole proprietor. Oh, my apologies. Key components of an estate, which I do need to discuss because those are important. Um, these are personal wills. And these are things that we need to put into place for a business to be able to have this business succeed in the long run, such as business succession plans, power of attorney, and buy sell agreements for the partners or even shareholders, depending on the circumstances of your business and the structure that you've actually um, provide like incorporated if you did incorporate a corporation. So, if you can elaborate, Ms. Vettyvel, about these aspects of estate planning, it would be really appreciated.
Sounds good, and thank you. So basically, what I will do is I'll just dive a little bit further into each of these points. So to cover the basics, basically, what is a will, right? So a will is a legal document that takes effect when you die, right? So it explains your wishes, how you wish for your property and your possessions to be taken care of and distributed once you die. So usually what we do is we'll name the executor and trustee of the will, we'll name the beneficiaries, we'll basically name the guardians if you have any minor children. So that's part of your personal will, right? So usually many people know that they need to get a will done, and it's most of us are usually familiar with the personal estate plan because it's usually one of the best ways to ensure your loved ones can fulfill your wishes after you're gone. But just like your personal assets, estate planning can also be a useful tool for businesses and corporations as well, right? So usually what as like when we're doing wills, what we always recommend is if you do have like a corporation or you've run a business, you need to be thinking as well about the business and how exactly you're going to distribute like the shares of the business and what's your business plan once you pass away. So a lot of people, what we do is we can actually do what's called a corporate will. So a corporate will is known as a secondary will, and it's an estate planning document that directs how your business interests will also be held in the private corporation and how it will be distributed after you pass away. So for example, if you're a business owner, you can create a corporate will that deals exclusively with your business while your regular will deals with your personal assets. And the best thing about this is that corporate wills are usually an exception to the recommendation that one person just makes one will. So usually if you end up having the secondary will, which is your corporate will, your secondary will is actually exempt from probate. So usually they will just take, there's been some court decisions in this effect as well, where the primary will would be the one that would be subject to probate, and they can exempt your secondary will from probate. So if you have a corporation, if you have a business, you can put what you plan to do with that business and who plans to inherit that business in that separate secondary will. And this could be a great planning tool for businesses so that they can minimize probate tax, because usually the ultimate goal is to try and minimize or reduce your probate taxes as much as possible. So that becomes very important. Buy-sell agreements are also an essential component of this as well, because in the buy-sell agreement, what you're able to do, as you know, is list each corporation and then list what will happen when a person passes away. So let's say in a given instance, a person has a business, right? But under their personal will. So even if they have a personal will and they say like if anything happens to them, everything will go to their daughter. But if you're running a business, that other person, let's say there's two shareholders or directors in the corporation, if one of them did not want to ultimately deal with the daughter for the business, the benefit of having the buy-sell agreement would be that it would give the opportunity for one of them to actually buy out the other person's share. So then that way, both of them benefit, because then the person can still preserve the business while the beneficiary can still receive the proceeds from there through their personal will. So these are all very important tools for estate planning. And when we are thinking about a person's estate plan in its entirety, it's important, yeah, to have the personal will, but it's also important to think about each of your businesses as well and what you want to do with it and how you want to structure it. Like if you want to do the corporate will, if you want to also have the accompanying buy-sell agreement so that there is a proper plan in place when the person passes away, I think that'd be very important.
Thank you so much. That is actually very informative. And it's actually really important, right? Like we do
Mhm.
need to consider all of these aspects when we're dealing with a business. So
Exactly.
those are things that we're going to go into a little bit more detail and discuss it a little bit more further. So let's first start by talking about the unique challenges for a sole proprietor.
Mhm.
So, as a sole proprietor, you have your own business, but all your business and personal assets are combined. They become liable completely to any kind of lawsuit, as well as death or illness. So, these are things we should protect ourselves from, right? And these are things that we should always be considering. We have no legal separation between the person and the business. So we should actually be considering any kind of options that will protect your business to make sure that you no longer will be at odds or confused, or your whoever is taking over charge will have a clear understanding of what your requirements are. This is why we do wills. This is why we do power of attorneys, to protect our business, but make sure that it's running according to our understanding of how we want to pursue the business. And that if you get better, let's say you get really, really ill, and then you get better. You want to be able to continue your business without going and saying, oh my God, what happened to all my profits? Now it's at a loss. Or what happened to all my shares? It's basically depleted or become very worthless. So these are things we need to consider. So let's go on to the next topic of unique challenges for partnerships. So this is also an important factor to consider in wills and estate planning, because you have multiple owners. Now, if you're conducting business with partners, your partner may not have a will, and you decide that you're dealing with all these things, and your partner may get ill. So at this point, what do you do? Because who is going to take that partner's responsibility on? Or what if your partner passes away? Does their shares automatically go to their family members? Now, are they going to have a input in all of your decision making when they have no idea about the business, or they have no understanding of how to pursue or continue the business? So these are things we need to consider in our wills and estate planning. So let's actually go deep into it and discuss it further. So, power of attorney for a sole proprietor. Why is this important? What does it actually entail for the sole proprietor? Let's ask Ms. Vettyvel how to make a proper power of attorney, as well as what the relevance of this power of attorney is.
Okay, thank you. So basically, just to do a deep dive on power of attorneys in general, right? So there's two types of power of attorneys that we mainly do, right? So there's the power of attorney for property, which governs how you wish to distribute your properties, like while you're alive, in terms of who has power to do what for you. And then we have power of attorneys for personal care. So keep in mind that power of attorney versus will. So a will is a document that comes into effect after a person passes away. A power of attorney is a legal document that's used while a person is alive, right? So what would happen here is that the power of attorney, in the event you can do power of attorneys a few different ways as well, right? So some people, you can do a power of attorney for your property. So let's say if you have property or a business, right, you can do like a limited power of attorney, so a specific power of attorney that just deals with that. So like if you, let's say for your business, wanted to do a power of attorney that specifically deals with your business only, you can do that. So you can do a limited power of attorney, and that would appoint, so in the event that you're out of the country or you're incapacitated or you have any issues, you can appoint someone to step in during that time for the sole purpose of the business only. Because usually if you do what's called the general power of attorney, which is for anything and everything that relates to everything except for in the event you become ill and you're in the hospital or making a new will, the general power of attorney would cover everything. So sometimes you may not want to give so much power to one particular person. So usually in a situation, especially for small businesses, we would recommend the limited power of attorney for either a sole proprietor or even within a company, right? So you can appoint a power of attorney to execute certain deeds for you. And you can also do this effective upon signing or effective upon incapacity. So some power of attorneys, like let's say you're going on vacation for 6 months and you wanted to terminate automatically when the person comes back, we can draft that for you. And we can put that in the power of attorney that says that it comes into effect immediately upon signing, and that upon like returning back, it automatically revokes and expires. And you could put what powers you wish to allocate. Same with the power of attorneys for specific businesses in the event of incapacity. So in that situation, you would say that the power of attorney does not come into force and effect unless such time that you become incapacitated, and then incapacity must be confirmed by like the power of attorney plus a medical physician, right? So usually then you take it to a doctor, get confirmation that they are incapacity, then the power of attorney would become effective. So usually that'd be a great way to utilize power of attorney documents, especially for sole proprietors or for partners, right? So in the case of a partnership, you may want like your fellow partner to have power of attorney in the event that you're incapacitated or out of the country or something like that. So they're very important so that it doesn't, like, the business doesn't shut down during illnesses, emergencies, vacations, and things like that. So just to recap, there's a couple of them. There's the power of attorney for properties. You can use limited power of attorneys. You can use it for anything. You can use it for your business operations. You can use it for personal property. People use it to manage real estate property all the time. You could do general power of attorneys, limited power of attorneys, and even power of attorneys for personal care, to say that in the event you become sick, like, how does your family take care of your end of life decisions? But especially for businesses, they're very important and very necessary documents.
Thank you so much for that information. I have another quick question. So, if we're doing a power of attorney, can I make sure that they actually deal with things specifically at my guidance?
Yeah. Yeah, so
So,
you could put whatever you want in the limited power of attorney. So if you want to put even the power of attorney saying I'm authorizing this person to execute, but they must receive, like, let's say you're available. Let's say in this event you're going to like Singapore for 6 months or something, right? And you want them to manage the business here. You can say that you can authorize the person to execute XYZ for you, but it must be subject to your consent. So like they can execute, get your permission, and whichever way you guys want to deal with that. So let's say by written communication, by email or something, right? They can authorize it and then they can execute for you. Because even though you're giving power of attorney, you may still be worried that like you don't want to give full power, you still want consent for things, right? So you
or
could definitely, you can just tailor it to the way you prefer.
especially if they don't have expertise or they don't have the knowledge how to run it, and you just
Exactly.
want them to step in at that point, but you want to give them guidance, right?
Exactly.
Perfect. That's exactly what I wanted to ask, because I wanted people to understand why power of attorneys are essential,
Mhm.
especially in a business. If you're not there for the day-to-day operations, you may not be able to see all the aspects of what is required, but someone who's there can look at it and give you the suggestions, as well as provide you with like a required consent, so that you can actually consent to that agreement. Okay, great. Now let's talk about partnerships. Partnerships, you did touch on this, and we are going to be a bit more detailed in this perspective. Partnership agreements and estate planning should address death of a partner, define what happens to the deceased shares, avoid automatic transfer to family. Why are these important, Ms. Vettyvel?
Yeah, so we recommend anybody who's forming a partnership, you must form a partnership agreement. So ask Nishanti or ask any lawyer experienced in corporate work to draft it for you, but you must have one. So basically, when an owner of a partnership dies, right, the partnership itself, unless there's a partnership agreement that specifies otherwise, it dissolves. It doesn't, there's nothing that specifically says like what would happen unless you address this in the partnership agreement itself. So a well-drafted partnership agreement can override the general default rule, right? That the partnership will dissolve itself. So usually your partnership agreement should have a provision for the death of a partner, such as the right for the remaining partners to purchase the deceased partner's share of the business in order to avoid, of course, the automatic transfer for family. So I want to just step in here for a quick second and just tell you guys what happens. So in case a person passes away without a will, right? So let's say you never bothered to make a will, you never bothered to make a partnership agreement, then you pass away, which is actually sadly a lot more common than we might think, right? So person passes away, they don't make a partnership agreement, they're in a business, they don't make a will either. Usually then what will happen is, in accordance with the Ontario Succession Law Reform Act, the surviving spouse will receive a preferential share of the estate, usually valued at $350,000 for those who died after March 1st, 2021. Remaining portion is usually divided between spouse or kids. If there's only one kid, spouse and the child will share it equally. If there's multiple kids, they'll share both equally. If there's a spouse, if there's no spouse and kids, the kids will inherit it. So you'll see here there's a pattern. It goes between the family, right? So in the event the partner wanted to inherit the business, it'd be very difficult if they didn't write a will or they didn't write a partnership agreement, right? Because it would naturally form like comply with the Ontario Succession Law Reform Act. So in this case, it's very, very important to write a partnership agreement and clearly define what will happen to the deceased share. So usually what it would do is it would clearly say that, okay, in the event that what this partner passed away, the other partner has the right to buy out their share at, let's say, X price. And then that way, at least the business can continue even though the person passed away. Because in this case of a partnership, it's not a corporation, right? So then usually you'd have to specifically write it in. Otherwise, it would automatically transfer to the family in a death, right? Because usually a will, unless the will specifically talks about that particular partnership and specifically allocates it as well, it would automatically go to whoever the beneficiaries are listed in the will. So many people who write a will usually say, I wanted to go to my spouse first, then I wanted to go to my kids first, and then they do not mention the partnership in the actual will, and they do not mention it in the partnership agreement as well, then that's when it would automatically transfer to family. So people have to be very careful here and make sure you guys are getting wills done, first of all, and getting partnership agreements that specifically define what will happen to their share. So you can say that, like, the other person can buy it out at X price or whatever the personal arrangement is between them. But it's very, very important, because otherwise, without this, and even without the will, it'll have a specific order of distribution under the Succession Law Reform Act, and it may not be what you wanted for the business.
Thank you so much for all that information. And I'm pretty sure my audience are like riveted by that, because to be honest, a lot of people don't go to lawyers because they think, oh, it's too expensive. Oh, I can't afford it. But I mean, these are things that you can't predict. Can you predict being ill? Can you predict being like going to die with by cancer or other means? You don't predict these things. You don't even predict if the company goes into an issue and you have financial hardship.
Exactly.
So how are you going to distribute the funds and the shares and the how are you going to deal with the business structure at that point, right? These are important things, right? We all have to consider them, especially as entrepreneurs and business owners.
Yeah.
Okay, so let's go on to the next topic. Buy-sell agreements. Why is this relevant? Let's talk about corporations first. Shareholders have buy-sell agreements for a reason, because shares in a corporation can be distributed to the relatives, and those individuals who have voting rights can make decisions based on those voting rights within a corporation. So that's important. But also partnerships have buy-sell agreements. Why is that important? Because if your partnership agreement, it says there's a buy-sell. If I was a partner with Rishani, and if anything happened to me and Rishani didn't have a buy-sell agreement, guess what happens? My family member gets the shares. But Rishani is like, oh my God, they have no common sense to deal with the business structure of a law firm, and they shouldn't be able to. That's not appropriate. So these are things we have to consider, right? And these are things that are very important. So in order to create our business structure, we would have to create a buy-sell agreement, which will allow Rishani to be able to buy my business portion and the shares that I own so that she could continue the business. But Rishani would get life insurance on my behalf in the partnership, which she would allow her to have that funds to be able to purchase the business portion of my portion and give that to my family members so that she would have that funds. But Rishani, can you tell me what are the other relevant factors that we need to consider in these buy-sell agreements?
From a will's perspective, usually what I always recommend to people is when they do, like, so from a will's perspective, it comes down to like the secondary will, right? So usually what most people end up doing is they will make their primary will, right? Their primary will deal with their personal assets, right? So they'll deal with their personal assets, and usually under what's called the residue is where they basically say everything, right? So they'll just be like, oh, I hereby authorize to direct the government to my residue to be given to my spouse. If not, I give it to both my kids. And then they don't usually mention anything further, right? So usually from a will's perspective, what we would then do is we'd either look to see if they have buy-sell agreements, right? So that would be like for each corporation, they would have their, like, whatever they own, right? They would have their corporation, and they would set out in there what the agreement would be, like what value would they buy their shares out, if the existing shareholders have the first right to purchase in the event of a death between the original person. And then usually that would be highly beneficial, because then what happens is they can pay out their portion, and then that portion then goes to the estate and can be distributed to the family without ruining the business, right? Usually the other way we do that as well is we also list it in the corporate will. So in the corporate will, we can also say that buy-sell agreements have already been in place, to please refer to the buy-sell agreement. So in the so that way also, because the corporate will specifically would avoid the probate part, right? So that's where that would come into play, right? So in a corporate will, usually what you do is it has a specific format attached, right? So usually you identify the person making the will, the address, you declare that this document is the testator's corporate will and that it deals with the transfer of their company shares, and you indicate that it's separate from any personal will. And then in there, you will start to talk about transfer of shares, to say how the shares will be transferred, like into a beneficiary, into a trust, things like that. And then even if everything has already been done in a buy-sell agreement, the corporate will can at least make reference to it. So say hereby authorize and direct that buy-sell agreements have already been drafted that clearly outline like the procedure upon death. Please refer to that document, right? So at least that way the family knows what to do, right? So if somebody passes away and they're just like, especially they may not be knowledgeable in like what their family member did for their business, right? But having these things in place, and I always recommend to people to have an Excel sheet of their family plan, right? So like have a central location where you have like your important information, right? Like maybe even where you keep your passports, like where you keep your will, where you keep all your important documents, where you keep your list of the bank accounts you own, the list of your businesses you have, like where you keep all your corporate documents. Have a central location of wherever you keep everything, like your life insurance policies or payment plans for things, like
share
for sure.
certificates.
Exactly, your share certificates, exactly. Like everything in a central location, so that in the event you passed away, your beneficiaries are not like running around like headless chickens. Like they have an organized spot and they know how to like follow it along, right?
Yes, that is actually important, right? Like,
Yeah,
no matter
exactly.
what, we don't know where, like, if my husband passes away or something, or I don't know where all his documents are, I'm gonna have to
Exactly,
go running
exactly,
after it and try. That's a lot more work for the family member.
exactly,
And if you
exactly.
don't know the amount of shares you have or the investments you have and all of the other investments that you've made, your family members would have probably lost out that investments, or it could end up being, transferred to someone that doesn't even have the access, or who knows what happens, right?
Exactly,
Because
exactly,
sometimes they have agreements within those investments. If someone doesn't claim it, what will happen to it? So
exactly.
these are concerns that every family member should have, and every entrepreneur and business owner should be considering throughout their whole business practice. This is why it is important to have these agreements. Always consider having these agreements, even if you are doing your agreement in the basic forms. At least make sure, if you're doing it yourself, make sure that you have a base outline of all the things and all the investments, but always check with a lawyer so that you can make sure that the agreements will apply to all the circumstances, even if you're trying to cut costs. At least if you have a foundation, the lawyer can look at it and build on it. So it wouldn't cost you more by doing that, right? So these are things to consider. Okay. So now that we've discussed this, let's discuss founding the succession plan. So how do we funding. How do we fund the succession plan? Is there something that we can do? So these are concerns that people always think about when they're dealing with funding succession plans. Here is where, as I mentioned earlier, life insurance can actually assist you, because you say, like, let's say you pass away, you can actually get a corporate insurance plan or a director's insurance plan. And these are things that can actually fund your succession plan and allow you to have the funds. If let's say I have a partner and I put a life insurance plan on my partner saying that if he passes away or if they pass away, then I would be able to get the funds for the corporation on his behest so that I could pay off the family members and get that shares back to my ownership or the corporation's ownership. So these are the ways that you can actually minimize the costs of any succession plans. Ensure immediate liquidity. So you can do liquidity where you can actually ask to dissolve the shares. And in a way, this is a bit more complicated and will likely result in a lot more funding requirements to be able to do that. So those you might want to speak to a lawyer first. Well, let's ask Ms. Vettyvel if what she thinks on these perspectives.
Yeah, no, I completely and totally agree with you. So I'd say the exact same thing. So firstly, when you're funding your succession plan, think about what life insurance policies that you require, right? Because a lot of people that I tend to speak to usually tend to be reluctant to get life insurance, like they don't want to pay monthly, things like that. But these are the things that are very important for your family planning, right? Because you never know what will happen at any time. Like something can happen next month to you, right? And you don't want your family to be in a position where things become much more complicated had you had life insurance, right? So we always recommend people to get life insurance. Also, just be careful to check when you are checking in terms of what is exempt from probate, what is subject to probate. So probate is a very long topic. There's a lot of intricacies in the process of probate, right? But what I'll do is I will quickly go over probate just so you guys understand it. So basically, probate is the process of certifying the legal will, right? So usually, if you want to certify your will for any reason, like if you need to transfer real estate or continue the business, things like that, right? Usually, you'd pay probate tax. It's usually $0 for the estate up to 50,000. So you don't pay any probate tax for the estate up to 50,000, and then after that it's 1.5% of the gross value of the estate, which is basically $15 for every $1,000 of the gross value of your estate. So you can see that this ends up becoming very expensive, right? So usually reducing probate in any way possible. Life insurance can actually reduce probate because it's a payout and it has beneficiaries listed. So that's actually one of the ways it reduces probate, which is very important as well for succession planning and things like that, right? And it also prevents like forced sales of businesses in that way as well. So it's very important that you guys are thinking about like the funding of the succession plan and how best to do this, whether through life insurance or other forms of insurance. Like some people get mortgage insurance on property so that it will pay out in the event that you pass away, even for your business insurance. So if you guys have an insurance advisor as well that you speak to, talk to them in detail about this stuff. And I know like people don't always like to pay monthly on these things, but they become very, very important when you're thinking about your family planning as a whole, like your business succession planning, what you want to do when you pass away in terms of your corporations and things like that. They're very important for sure.
Exactly. And don't just go to one insurance agent. If you feel that you need to, you can shop around. You could ask questions to multiple insurance agents to see what their options are. There might be an insurance agent that might be able to give you a long-term insurance plan that might be a little bit expensive in the beginning, but over the course of time, it would not actually double because of your age or your capacity to earn. These are all things that you should consider because I also, as a lawyer, have insurance, but if I get a 5-year term, then after that 5 years, because of my age being older, I can incur more charges or more insurance. So these are all things that you should consider when you're dealing with insurance because it'll help you understand what are the possibilities. And there are so many different possibilities for insurance that you can talk to the insurance agent, how you can get those insurance appropriately for your business, for yourself, for your family, for whatever circumstances. But don't ever cancel your insurance in the middle of looking for an insurance because sometimes people die in the middle at that point. There has been incidents where that person was shopping for an insurance and they thought, oh, I'm going to go with this insurance and I'm going to cancel this insurance. And then they get ill right in between. And then they pass away and their family's left with nothing. So these are all considerations you have to make when you're dealing with matters that concern your family and protecting your business. Okay. So let's talk about tax considerations in estate planning. As Ms. Vettyvel has explained, we discussed probate fees, and she will actually elaborate a little bit more if she can do that. I think she's already elaborated quite a bit on that, but either way, we'll talk we'll ask her in a bit. The other potential is consider capital gains on death, as well as opportunities for tax deferrals. These are all things you should be speaking to a tax accountant about because although Ms. Vettyvel is very knowledgeable about probate, we are not tax accountants. We do not have an understanding of what the tax consequences are going to be at your death if you do not have a proper will or estate planning. And at the same time, even if you do, at the end of the day, it depends on the value of your estate and value of all the investments and any kind of business structure that you have that will depend on the taxes. So at this point, I'm going to hand it over to Ms. Vettyvel to explain a little bit more and let her have her input on what she needs to clarify. Which is already done.
So exactly. Thank you for that. So basically, when it comes to tax considerations in estate planning, right? So you have to be thinking about these things because the last thing you want to do is you're in a situation where someone's passed away, you're already mourning for them. The last thing you want to do is pay a whole bunch back to the government as a result of somebody passing away. Right? So usually one of the main things in your estate planning is to think about how you can reduce how much taxes you have to pay as much as possible in ways that are obviously legal and allowed, of course, right? So basically probate taxes, right? So I know I already touched on probate fees before. So what it is probate fees or probate taxes. This is a tax that must be paid to the government when an estate is probated, right? So probate means, okay, someone passes away. In order to be able to do anything with that will, you need to go get that will certified. Right? When you get that certified, that's the process of what they call probating the will, right? So when you do that, what they will do is they will calculate the total value of how much your estate is worth, right? So like depending on how much your estate is worth, usually they have a very detailed calculation of how they do this. So they calculate all your properties, anything that you've held in joint tenants with another person is exempt, right? So that will not count as part of your estate. And what they will do is they will calculate how much your estate is worth, right? So like if you had any properties in your own name, if you had businesses in your own name, if you had like whatever you had, they will calculate the total value of that amount. And then you're subject to pay a tax on that when you certify the will. So the tax that I was mentioning earlier in this webinar, there's no probate tax on the first $50,000 of your estate. And then after that, it's $15 per $1,000 of estate over $50,000, which works out to 1.5% of the gross value of your estate, right? So usually that can end up becoming a lot of money, right? So people don't want to pay this much money. So usually you need to be thinking about these things in your estate planning because in the context of, let's say, property, for example, you can avoid this. Like if you are the only person on title, you can avoid this by going as joint tenants with another person. And then you're no longer paying probate fees on that particular property, right? Same with businesses as well. You can, what you can do is with businesses, if let's say you have a corporation and you have like 3 directors, and then in the event a person passes away, these buy share agreements, these corporate wills, where another person buys out your portion and the balance goes to the estate. That way, that can also be avoided in the calculation of probate as well. So these things are important. If you're a sole proprietor, as we were mentioning earlier in this webinar, then usually the business will die with you because you're a sole proprietor, and then whatever assets you had will go as to your personal will, and then you pay tax on that. So usually these things, like, and then if you're in a partnership, then the best way, of course, we've said throughout this webinar, is get a partnership agreement. If you don't have one, go to Nishanti and get a partnership agreement done, right? So basically these are important because if a person passes away, then you need to have something that documents what will happen, because otherwise then your portion goes to your estate, gets subject to probate tax, and you pay more money, right? And also potential capital gains is usually as a result of sale of property. So usually if you have a property and you've certified the will and then you've transferred that property, then a person sells the property, that's usually when you're subject to capital gain tax and stuff. To avoid all of that, it's good to just take all your properties, take all your business, take whatever you have, look through them, and then just find whatever's best for your particular family and situation, work accordingly. And for tax deferrals, just talk to a tax lawyer about that.
So thank you so much for that. And Ms. Vettyvel has explained it so thoroughly. And at the same time, she is being very modest. She knows exactly how to create a proper will that will allow you to benefit in several ways. So always talk to a proper lawyer who can do that will for you, right? And
Sure.
we well, we've discussed so many things today, and so let's go to the next topic, the role of executor and successor. This is a complicated topic. Although we're not going to get into too much detail, I'm going to get Miss Vettyvel to explain a little bit about what this entails and how it could assist you in being able to deal with your wills and estates properly.
Okay, yeah, this is a very important topic. Tends to be an obvious one, but surprisingly not as obvious as one would think, right? So I'm going to take this in two parts, right? One is choosing your executor for your personal will, and then, of course, choosing your executor in terms of your business, right? So when you have your general will, your personal will, right, whoever you appoint as your trustee, right, you want to make sure that that person, first of all, is someone that you trust, right? So you trust them to distribute your assets to your beneficiaries, right? And secondly, someone who understands stuff, right? So usually, like when I take a client, right, and like I'm talking to the client, and you so let's say, for example, it's like elderly parents that want to do wills, and then like I ask, let's say the husband, like, does your wife have an understanding of like finances and like the businesses you own and stuff? And if their answer is like, no, she genuinely doesn't, she was never involved, usually I'd recommend like appointing a trustee or that understands that stuff, right? So even if they want to be joint with your spouse, like if your spouse may take, for several reasons in a family, right? They may take personal offense if they're not the trustee. Like you can have them joint, right? So joint trustees is definitely possible. So let's say you want to be joint with, like, let's say one of the business partners, or you want like a trustee for the purpose of some of the businesses, right? So if you're making the corporate will as a secondary component, you could say, in relation to my business, I'm appointing X person to handle the affairs of the business. And it may be a person that understands business operations, they understand what to do, right? So it's very important to appoint people that actually know what they're doing, because a lot of times, like, we've seen situations where executors don't want to be executors. Like, so they find out that they're a trustee under the will, and they say, like, I don't want that kind of responsibility. I don't want to do it, right? So you have to make sure that you're appointing someone that A, actually wants to do it, and B, like actually understands like how businesses work, how to actually like probate a will, what to do, right? So that they're not like, so that they're better prepared, right? So usually we tend to recommend people that are like within Canada. So let's say you're in Canada and you are drafting your will. We always recommend appointing a trustee, like also in Canada, also in Ontario, so someone easy to communicate with. If you don't and you appoint someone overseas, it's fine if you have regular relationships with them, but keep in mind, if something happens to you, they have to execute everything. So if they're abroad and stuff like that, if they're willing to do it, it's fine. But usually we find that like people who are here locally will be the ones to assist you. But even not, if you have people in the States and stuff and they understand business operations, you could choose them. But we always tend to elaborate on people that are here, but it can be whatever works for the family.
This is important because appointing someone who is going to take responsibility for all of your business and your shares or whatever circumstance it is, if you're an entrepreneur, sole proprietor, partnership, corporation, whatever it is, they will have to be able to take this responsibility and move
Exactly.
forward exactly like you would have done. Correct?
Exactly.
So this is important. So consider your executor and successor. And I understand that this is going to cause a lot of issues for a lot of people because I've worked in court services. So I've seen litigation where people are against the executor because they don't believe that person is right. But you're the only one who's an entrepreneur who will know what is the right decision for you. And if you choose that executor and make that plan and hire Miss Vettyvel to create your will or your power of attorney, then you can make it strong enough that it can't be contested in court
Exactly.
because of the fact that you've given that direction. And Ms. Vettyvel, as a knowledgeable and experienced lawyer, will make enough information available to the courts indicating that here, this is what the actual individual wanted. And this is how it should be played out. So, this is where it's important because you do get lawsuits. A lot of times when people pass away, even if they have a will, there is a lawsuit always occurring. And I've encountered it, I've seen it, and I've witnessed it on several occasions where family members are like, no, this individual shouldn't have that power. but in reality, they've already been chosen. So it's still going to happen, but at least the company will benefit, and so will all of your business structures and your decisions that you've made. So that's important because you're looking out for your best interests and the future of your corporation or your business. Now, let's talk about common mistakes to avoid. What are the common mistakes that most businesses tend to avoid when they are dealing with these kind of situations where they need a succession plan? Can you elaborate a little bit, Ms. Vettyvel?
Of course, yeah. So usually we see the points listed here quite a lot, right? So usually common mistakes, right? Not updating your estate plan as businesses grow, right? Like this is a very common thing, right? Like I'm sure you see this all the time in your practice, right? People start off with like 2 directors, they grow to like 5 directors, 10 directors. At the beginning, people tend to draft these agreements, right? Actually, some people don't. Like you'll be surprised how many people don't. But like some people, like those who draft these all their contracts, their buy-sell agreements, they draft their wills, they do everything at the beginning. And then their business grows to like 20, 10, 20 people. And you see that they haven't actually updated their buy-sell agreement, right? So if someone passes away, then it doesn't accurately reflect what they wanted for the business, right? So, or people that maybe join later have now missed out on the opportunity to buy the shares of the other person, right? So it's very important we always recommend that everyone review their estate plan every 3 to 5 years, like at maximum, right? You should be doing this all the time, but at least every 3 to 5 years, review your estate plan, see what's changed. You might have the kids that were minors that are now over the age of 18. You may have people in your business who have now joined, people who have left. You might have done like amendments to the corporation, right? So always make sure that you are double checking and you're updating your documents so that it reflects you at your current point in time. And especially if you make a change or anything, make sure you're updating your documents accordingly, right? So also another mistake is that a lot of people make personal wills, but most people tend to miss like the corporate wills or thinking about the business or laying out agreements that specifically talk about that business and then what happens if you pass away, not realizing that like if you pass away and you haven't said what would happen to the businesses, it will go to the beneficiaries and that may not be what people in the business wanted, right? So that's also very important. So make sure with your personal estate planning, which I find people tend to do, make sure you're also doing your business succession planning, right? So both of them have to work hand in hand, especially if you own like multiple corporations and you've been running, let's say, like a restaurant business for 15 years or whatever it may be. You may have specific plans and you have to make sure that you've planned that out separately because you may not want it to go to your kids when you have like they may not know how to run the business after the business might fail, right? Especially with businesses that heavily rely on the person itself doing it, as like people may come to the business for that person, right? So if you don't plan properly, then you could drastically affect the quality of your business as well, right? So you must coordinate your personal and business planning. They must be done together, right? Your personal planning for your life as long as with your business planning so that it's a proper estate plan. Like look at the businesses you own, look at your properties you own, look at your life as a like basically like as a whole, right? And then ensure that you're doing your planning properly at all times.
This is important because depending on the kind of business you're running, you might have no idea how to
Mhm.
separate like let's say you have investments in as a sole proprietor. How do you separate it? How do you know which is separate, which is business and which is personal related? So these are things that we need to consider on a regular basis every time we actually deal with any kind of business planning, succession planning, any kind of protection for our business. This is important. Thank you so much for that information. That's
No
actually really
problem.
good
No
for
problem.
I'm pretty sure our audience is like riveted by all of this information.
That's amazing.
Okay, let's go on to the next slide. Well, I guess we're almost to the end, and this is where we're going to say important facts to remember, important things to remember. Succession planning. Always speak to a lawyer. Speak to Miss Rishani Vettyvel. She'll give you information and she'll be able to guide you in the right direction in preparing your wills and estates. And This is important, understanding the role before accepting it. So any kind of role you accept, any kind of business structure you're dealing with, make sure you know what kind of will or estate planning you require for you to move forward in case of an emergency, in case you need a power of attorney for someone to take over the business on a short-term or a long-term basis, especially if you're not able to continuously be there. That is when you know you need a power of attorney. And a will is important in case some kind of illness comes up. You should also have insurance plan just in case, but a will allow you to determine the specific instructions that you're providing for your business to continue to be successful and be able to gain that success long term, including if you want to make sure that your family is protected with funds and proper, if the business goes under, then your family's losing out all that money that you could have probably provided to them as a business succession. Sorry, that word just doesn't work with me. Succession. Know your responsibilities, ensure you protect everything, including your business structure, your plan, yourself. Just make sure that you learn about these aspects and write it down. Understand what you have by writing these things down and figuring out, what do I need to do? And then you can go to a lawyer with specific questions. Those are important. You don't have to be the most knowledgeable person, but you need to know what you need to do in the future to protect yourself. Is that correct?
That is completely correct. I 100% agree with everything you've said.
Do you have anything else that our audience should hear that is important for them to know about the business and wills and estates?
I'm just going to highlight again. Please watch the presentation in its entirety, and please make sure you are doing your succession planning, whether it's your personal, your business. Make sure you're doing them together, and make sure you are seeking the right professionals for anything you need. If you need to get your will done, please feel free to call us. And if you've also realized that you haven't done your partnership agreement, your shareholder agreement, please call Nishanti, get these things done. Make sure that you guys are doing your family planning properly, because you never know when something's going to happen. And it's much less stressful for your beneficiaries when everything is already put into place.
Especially litigation. Trust me, it's costly. And as a litigation lawyer, I know a lot of clients come to me after the fact and they haven't prepared before the fact. And this is where it costs them way more in the long run or they could have just prepared an agreement or a contract in the beginning, preventing all of these aspects from coming up. And so they would have protected themselves.
Exactly.
But, what can you do? Sometimes you end up in that situation. You have to talk to a civil litigation lawyer and you end up spending over $100,000 in lawsuit fees. So consider all of these aspects.
For
Really.
sure. Totally agree.
Right? Important things to consider. And finally, this concludes our presentation. And thank you so much to Rishani Vettyvel. Sorry, I keep saying your name wrong. I do.
No problem at all.
I know your name. It's a brilliant name, Vettyvel. But I'm really bad with names.
Yeah, no problem at all. No problem.
She's such a great speaker, and I'm so happy to have you on my webinar today. And it was such a pleasure. Thank
No
you.
problem. Thank you so much for having me.
Thank you, everybody, for coming, and we'll see you next week.
No problem. Take care.